Case summary. L Estrange v. F. Graucob Ltd. 1934, 2KB 394. In the case of L Estrange v. F. Graucob Ltd., the plaintiff, Mrs. L Estrange, entered into a contract to purchase a cigarette vending machine from the defendant, F. Graucob Ltd. The contract was a standard form agreement, which Mrs. L Estrange signed without reading its terms. When the machine proved to be defective and unfit for its intended purpose, Mrs. L Estrange sought to rescind the contract and recover her losses, claiming that she had not been made aware of the exclusion clause which exempted the defendant from liability for any defects. Background facts. Claimant plaintiff, Mrs. L Estrange. Defendant, F. Graucob Ltd. Facts 1. Mrs. L Estrange operated a cafe and wanted to purchase a cigarette vending machine. 2. She entered into a contract with F. Graucob Ltd., a company that sold such machines. 3. The contract was a standard form provided by F. Graucob Ltd. and contained several clauses in fine print, including an exclusion clause that limited the company's liability for defects. 4. Mrs. L Estrange signed the contract without reading the detailed terms. 5. After installation, the machine did not work properly, and Mrs. L Estrange sought to return it and claimed damages for her losses. Argument. Plaintiff's argument. 1. Mrs. L Estrange argued that the machine was not fit for its intended purpose and sought to rescind the contract based on the machine's defective condition. 2. She claimed she was not aware of the exclusion clause because she had not read the contract in detail. Defendant's argument. 1. F. Graucob Ltd. argued that the exclusion clause in the contract exempted them from liability for defects. 2. They contended that Mrs. L Estrange, by signing the contract, had agreed to all its terms, including the exclusion clause, regardless of whether she had read them. Final outcome and legal justification. Outcome. The court ruled in favor of F. Graucob Ltd., upholding the exclusion clause. Law justification. 1. The court relied on the principle of contractual autonomy, which dictates that a party who signs a written contract is bound by its terms, regardless of whether they have read or understood them. 2. The court referenced L Estrange v. F. Graucob Ltd. as a precedent for the doctrine that a signature signifies consent to all terms in the contract. 3. The principle that the party is bound by their signature was upheld, reinforcing the notion that it is the responsibility of the signatory to read and understand the terms before signing. 4. The exclusion clause was clear and unambiguous in its wording, and there was no evidence of misrepresentation or deceit by the defendant. Key concept. Implication of the case. 1. The case reinforces the binding nature of signed contracts and the importance of reading and understanding all terms before signing. 2. It emphasizes the principle that a signature constitutes consent to the terms contained in a written agreement. 3. The decision underscores the enforceability of exclusion clauses, provided they are clearly stated and unambiguous. Key lessons. 1. Always read and understand the terms of a contract before signing. 2. Be aware of exclusion clauses and their implications. 3. Understand that a signature on a contract binds you to its terms, barring instances of misrepresentation or fraud. The L Estrange v. Graucob Ltd. case is a cornerstone in contract law, emphasizing the doctrine that individuals are bound by the agreements they sign, which underscores the importance of diligence and caution in contractual engagements.